starting now. Welcome, everyone. It is my pleasure to introduce our speaker today in today's Madame Curie Speaker Series, Professor Michael Gerard from Columbia University School of Law. This is one of those exceedingly easy introductions to make because everyone knows Michael. He has been heading the Sabin Center for Climate Change Law at the Columbia Law School for, I guess, over a decade now, certainly. And as in that capacity, he has been at the forefront of issues dealing with how to adapt law to deal with the challenges of climate change and to promote effective policy responses. He also, of course, has had a distinguished career in other capacities. Outside of law, he was chair of Columbia University's Earth Institute from 2015 to 2018. He has practiced law for a long and distinguished career with Arnold & Porter, where he has been the partner in charge of their New York office and also is named as the top environmental lawyer in the United States. He's also been a prolific author and has worked probably with many folks on this call on co-authoring books on a wider range of topics from brownfields to environmental justice to climate intervention law. Today, he's going to be speaking with us about some of the challenges in terms of needed permit revamping to be able to respond effectively to climate change. With that, before we begin, I just want to remind everyone that Professor Gerard will be speaking for approximately 40 minutes. During that time, you can post any questions you'd like to ask into our chat box. Both Alban and I would be monitoring and curating those questions and provide an opportunity for responses at the end of this session. With that, the microphone is yours, Michael.
Tracy, thank you very much. It's a pleasure to be with you all virtually today. I see on the screen several people who know a lot more about some of the things that I'll be talking about than I do. So I hope that we can have some discussion after I talk. So I'm first going to briefly set the stage with where we stand in trying to meet the Paris climate commitments, then about the scale of the challenge in building out renewable energy facilities, which is an essential part of meeting the Paris agreements, and then I'll dive into the subject of thoughts on expediting the permitting process. So let me start by sharing my screen. There, can you see that?
Yes.
How's that? Very good. So this slide shows the levels of greenhouse gases in the atmosphere in terms of parts per million, going back to 1960. The colors indicate global average temperatures. So red is warmer, blue is cooler. And we see here the major UN climate agreements, notably the UN Conference on Climate Change in 1992, the Kyoto Protocol, the Paris Climate Agreement, and so forth. So the climate doesn't care about these agreements. The effect of these agreements on the actual levels of greenhouse gas emissions in the atmosphere is imperceptible. So this is levels of carbon dioxide in the atmosphere. This is emissions from fossil fuels and cement. You see that has continued to go up. There was a decline in the fiscal crisis of 2008, 2009, but it went back up. A decline due to COVID. We're now higher than we were before the onset of the pandemic. So emissions have continued to go up. As you all know, under the Paris Climate Agreement, each country agreed to put forth a pledge, a nationally determined contribution, that it's NDC, for how much it was going to reduce emissions, with the objective set in Paris of keeping global average temperature increases less than 2 degrees Celsius, 3.6 degrees Fahrenheit, above pre-industrial conditions, and trying very hard to be as close to 1.5 degrees as possible. So where we are now, we see these are what the actual emissions have been, the global emissions. This is what the trend is and the policies that are actually in place. The national pledges the NDCs would take us to here. This is where we need to be if we're going to be at 2 degrees, and this is where we need to be in order to be at 1.5 degrees. So we are way off track to meet the Paris climate goals. Even the aspirations set forth in the NDCs are way off track. What is actually happening is well below what is worse than what the aspirations are. We also know that the Inflation Reduction Act passed earlier this year by Congress on top of the Bipartisan Infrastructure Act and the CHIPS Act and various other things, is providing an enormous amount of money for renewables and is advancing progress. So for US greenhouse gas emissions, we see this is what they actually have been. Now, the decline we've seen, the largest factor is cheap natural gas, which has allowed a lot of electricity to be generated by natural gas rather than coal, and various other factors. So it's been going down out to 2030. Continuation of business as usual projected to take us here, the Inflation Reduction Act here, and to be consistent with President Biden's goal of a 50% reduction in greenhouse gas emissions by 2030 would be down here. So this gets us much of the way, but not nearly all of the way. And achieving the potential of the Inflation Reduction Act and these other actions requires a very large build out of renewables as well as various other things. A project called the Deep Decarbonization Pathways Project, that was the technical basis for a book that John Dernbach and I co-edited called Legal Pathways to Deep Decarbonization, set forth these 4 pillars, but these generally represent a consensus among the analysts who look at it, that what we need is first electricity decarbonization, moving almost entirely away from fossil fuels to generate electricity, at least unless it has carbon capture and sequestration. A great increase in energy efficiency, electrifying whatever it is we can electrify, led by motor vehicles, and also space heating and water heating and so forth, and then carbon capture for the hard to emit sectors and a lot of direct air capture. But one element of this, a result of electrification, of moving so many things to electricity, is we need to around double the supply of electricity. That a lot of the energy that had been supplied by fossil fuels to run motor vehicles and so forth would instead be operated by electricity. So we need about a doubling of electricity. And we need to be doing that almost entirely with clean energy sources. Where we are now, renewable energy provides only 12% of the primary energy that is used in the United States, and 8% for nuclear, so that's 20%. We need to go from 20% to as close to 100% as possible. So we've got a heavy lift ahead of us. One depiction of that was released a year ago by the Biden administration at the Glasgow UN conference. They set forth their conceptual pathways to how to get to net zero greenhouse gas emissions by 2050, which is where we need to be roughly in accordance with the Paris temperature targets. And they set forth the idea that fossil electricity generation would drop. You've got a range here for each one under different scenarios, but would drop precipitously, and renewables would grow exponentially over this period of time. And they're also hoping for whatever fossil remains has carbon capture and sequestration, which has not necessarily been going so well on a timing and economic basis. A couple of scenarios for the magnitude of build out we need. There was a study led by some people at Princeton, called the Net Zero America study, that looked at a couple of different scenarios. One where we're relying 100% on renewables, and the other where we still have nuclear and CCS and some other sources. So the annual capacity increase that is needed. So each K here is a gigawatt. A good-sized nuclear power plant is about 1 gigawatt. So looking here for, if we're relying entirely on renewables, for about the equivalent of 15 nuclear power plants each and every year out to 2050 in offshore wind, and onshore wind, the equivalent of 87 nuclear power plants each year. If we are relying on, if we're also using nuclear and CCS and so forth, only the equivalent of about 15. But under any of these scenarios, it's a very large build out. This is the current footprint of wind and solar around the country, utility scale wind and solar. The wind is in blue and the solar is in orange. If we're going to be building out to the scenario of full renewables, this is what it looks like. We have just an enormous amount of wind and solar all over the country. A different set of calculations by a different group looked at the magnitude of capacity additions that would be needed by 2030 if we are to achieve 80% clean electricity by 2030. President Biden has called for 100% clean electricity by 2035. And this is broken down by wind and solar and some battery, and you can see a large amount of capacity that is projected to be needed in almost every state. The Pacific Northwest doesn't require much because they have such a large amount of hydro, but for the most part, we have an enormous amount of new capacity that is needed. In order for the new electric generation capacity to reach its load to serve its customers, we also need a corresponding increase in transmission. And under some scenarios, we would need 3 or 4 times as much interstate transmission as we have now, and a much larger increase in the pace at which transmission is built. The good news, of course, is that the money from the Inflation Reduction Act and the CHIPS and Science Act and the Infrastructure Investment and Jobs Act, the Bipartisan Infrastructure Act, is throwing it's a huge amount of money going into clean energy, as this shows on an average annual basis for the years 2020 to 2029, we would have this much federal money going into it. And of course, the federal money will spark hopefully larger private sector investments. And this is about 4 times the maximum amount of federal money that we've ever had before, the peak under the American Recovery and Reinvestment Act of 2019. All of this is also going to greatly reduce the cost of providing renewable energy. An analysis by the consulting firm ICF looked at the levelized cost of energy in 2030. Levelized cost, of course, is if you take the expected lifetime of a renewable energy facility or any energy facility and amortize it over its lifetime, what the annual cost would be, annualized, add to it the operational cost. Under this calculation for wind and solar, prior to the Inflation Reduction Act, this is where it had been. And with the IRA, with blue bars, it's here. Now, wind and solar, of course, are much cheaper today than they were 10 years ago. The cost of both has plummeted, but the IRA makes them even cheaper. The IRA has major subsidies for batteries and hydrogen and carbon capture and sequestration, not for natural gas. And so wind and solar now under the IRA will have a levelized cost, which is far lower than that of natural gas, and become the cheapest ways to provide electricity. But all this has to get built. And there is the rub, or there is a rub. The poster child of what we don't want to happen was the Cape Wind project, a proposed wind farm off Nantucket and Cape Cod. The applications were filed in 2001. It went through a tortuous process with several environmental impact statements, multiple litigations, lots of changes in government policy, some local opposition, largely from rich people on Cape Cod who didn't want to look at wind turbines. And 15 years after the application and at least tens of millions of dollars of expenditure, the project collapsed, was canceled. So that's what we don't want to happen. And so in theory, just about everybody likes the idea of speeding up the permitting process and making it more certain. Unfortunately, in making that happen, we have to confront quite a few trade-offs. And I think distributed with the announcement for today's program was an article that I just published in the Environment Forum magazine from the Environmental Law Institute about those trade-offs and the importance of confronting them. So species habitat is one important trade-off that we're going to be needing to build a lot of wind and solar in places where there are species, some endangered species that live there now, and that might be harmed by putting these facilities there. I'll say more about that in a couple of minutes. The visual impacts, wind in particular, you want to put wind turbines where the wind is. And if you're on land, it's on top of ridge lines. And we've seen that the wind turbines are getting taller and taller. It's more, we have technologies for that are more and more efficient. Offshore, it used to be that the plans could be seen for the turbines could mostly be seen pretty well, but the more modern ones are more like 30 miles off and can't be seen, but they're still concerned about the visual impacts. In terms of private property rights, little or no condemnation of land is required in order to get the land to directly put the wind and solar on, because there tend to be a lot of landowners who are happy to sell or lease their land for the turbines. The same is not necessarily the case with transmission lines, since the transmission lines have to traverse large areas, across a lot of land. And so a considerable amount of eminent domain often has to be exercised to build out the transmission lines. A lot of these facilities, or at least some of them, are going to go on farmland. Now, again, these are the farm owners voluntarily leasing their land for this. There are concerns that have been expressed about taking away farmland for renewables, although I have to say that something like 30 million acres of farmland in the United States are currently used to grow corn for ethanol. That's an area about the size of Louisiana. And on a per acre basis, solar panels generate about 30 times the energy as the ethanol from corn. And that's not even counting the energy efficiency superiority of electric vehicles over internal combustion engines, which are the kind of vehicles that use ethanol blended into their fuel. We also hear concerns about taking down trees. We've done some calculations showing that if you take down trees and replace them with solar panels, although taking down the trees releases the carbon in the trees into the atmosphere if you're not reusing or storing the wood. The energy payback or the greenhouse gas payback from the solar panels happens in 2 or 3 years. That within 2 or 3 years, you've offset greenhouse gas emissions, the equivalent of what you've lost from the trees. Now, of course, trees serve other ecological functions, so that's not the only factor. But taking down trees for solar panels turns out to be a positive from a greenhouse gas perspective. Local control is another important trade-off. In most places, the municipalities have zoning authority and can block or modify facilities that they don't like. I'll return to that in a minute. Public participation. It is very important to involve the public in these discussions, but if that takes a very long time, if you have continual meetings over a period of years, it can really add greatly to the timeline involved. We also, of course, have a regrettable history in this country and many other countries of citing environmentally damaging facilities in disadvantaged communities, and we now realize that we need to be moving away from that. With respect to renewables, it becomes a particular issue in tribal lands and consultation with the Native American communities to talk to them about what might be sited on their lands. Another trade-off is the depth of the studies that have to be undertaken. An environmental impact statement under the National Environmental Policy Act, NEPA, for a major project can be several volumes and cost millions or tens of millions of dollars to prepare and take years to prepare. So if there is less depth in some of the studies, that can be done faster. But there are trade-offs in terms of not having the same level of analysis of all these issues. One excellent place to put some utility scale renewable energy facilities is on contaminated lands. But conventionally, there are liability concerns and disturbing contaminated lands under the federal Superfund law and state equivalents and various other laws. And so cleaning up these lands so that people can live on them and then putting wind or solar may not make a lot of sense. And there's some legal things that can be done to adjust that. Another trade-off to be considered is the extent of litigation that can be allowed and where and when and how long it can take. Domestic content requirements. The Inflation Reduction Act requires that in order, for example, for the full electric vehicle credit to be available, a lot of the components that go into the cars, including the batteries, much of them have to be made domestically. There are important policy reasons to do that in terms of job creation, in terms of the U.S. industrial policy, in terms of getting the necessary votes in Congress, but it does have the potential to slow down the introduction of some of this equipment. We also have issues about the labor standards for supply chains. Some solar panels are made in China in parts of the country where they have essentially slave labor by the Uyghur population. Other places have child labor for mining materials and so forth. So paying attention to that also impedes certain of these activities. Another trade-off is that as a political matter, taking measures that would allow the speed up of the approval of renewables would probably also speed up the approval of fossil projects, which causes problems. So as I said, one of the trade-offs involved concerns local participation. Our center at Columbia started up something called the Renewable Energy Legal Defense Initiative, which provides pro bono legal assistance to communities and others who want wind and solar and also associated storage and transmission, but that are facing local opposition. So we've been doing an examination of where this local opposition has popped up. And our most recent report identified 121 local ordinances around the country that restrict renewables and 204 contested renewable energy projects. The local ordinances are sometimes temporary moratoria, sometimes they're outright bans, sometimes they're de facto bans by, for instance, setting setback requirements that can't be met, particularly for a wind farm, or zoning amendments that are designed to block a specific proposed project. So this is where we have found the local laws restricting renewable energy projects. The largest number of them is in Indiana. Texas is number 2, and New York is number 3 in terms of the number of these local laws. And where the opposition has, where we see local opposition, every state, again, except for Mississippi, is seeing opposition to particular renewable energy projects. Now, one legal technique that has been used successfully to deal with this sort of thing arose in the context of the construction of cell towers. In the mid-1990s, as mobile phones were really expanding in use, a difficulty was that a lot of localities were banning cell towers. So in 1996, Congress enacted the Telecommunications Act of 1996, and one of the many provisions of it concerned local zoning authority over these cell towers. Now, Congress did not take away local zoning authority, but it said that a state or local government must act within a reasonable period of time on an application for a cell tower, that if they are going to deny a request to build one, that denial has to be in writing and supported by substantial evidence contained in the written record. So they can't just say, we don't like it, we're disapproving it. They have to issue a written opinion explaining why they're opposing it. Congress also said that a locality could not ban a cell tower on the basis of radio frequency emissions, electromagnetic frequency radiation. They said that is the job of the Federal Communications Commission to set the acceptable levels, and a locality could not ban a cell tower that would comply with the EMF regulations on that basis. That was solely the FCC. Then, very importantly, the statute provided for a route into federal court, that someone who wanted to build a cell phone tower that in a locality that was excessively delaying it, or didn't explain its reason for denial, or was denying it because of EMF radiation, that they could go to federal court and seek relief. This has been fabulously successful. After 1996, after the enactment of the statute, we saw an enormous increase in the number of cell sites that are installed every year. And probably everyone on this phone utilizes mobile phones and takes advantage of this having happened. So this would be a federal statute. At the state level, in 2019, the New York legislature enacted the Climate Leadership and Community Protection Act, which is requiring a very large build out of renewable energy in New York State. The legislature realized that the process that we had here in New York to approve utility scale renewables was much too slow. There was a law called Article 10 of the Public Service Law, but the approvals for utility scale renewables were proceeding at a snail's pace. And so in 2020, the state legislature in New York adopted the Accelerated Renewable Energy Growth and Community Benefits Act, which basically which created a new entity, the Office of Renewable Energy Siting, within the New York State Department of State, to be one-stop shopping for the approval of utility scale renewables, one-stop state level siting. It can't overcome any federal requirements. So a locality no longer has zoning authority over these facilities. However, the local zoning restrictions and requirements apply unless this office says that they are unduly burdensome, in which case it can disregard them. So applicants go to this one central state office. It's a very detailed application process. They don't have to go through the State Environmental Quality Review Act, the state equivalent of NEPA, but the documents that are prepared are basically the functional equivalent of that, and there's an equivalent level of public hearing and opportunity for comment. As soon as the statute allowed developers who were already in the queue of the old Article 10 process to stay there or move to the new process, miraculously, the old queue sped up. It had been run by a siting board under the State Public Service Commission, and in short time, about 10 projects that had been held up started, moved through it and got approvals, and now this new law is processing facilities well. So it's still early. This law is only 2 years old, but I would say the early indications are that this state law is working well. Another major impediment to building these facilities, as I alluded to, of course, is the impact on species, and the most prominent element of that is the danger that wind turbines pose to birds and bats. Put in perspective, however, if you look at what is it that kills birds, windows flying into windows are by far the highest source of bird mortality. Feral cats are number 2. Wind turbines are way down there, and even if we have a massive increase in the number of wind turbines, it's still going to be a low number. And of course, when we talk about trade-offs, we're in the middle of the 6th great extinction in geologic time, and largely, not exclusively, but largely caused by climate change. It's going to get worse. We're going to have a lot more extinctions if we don't have this massive build out of renewable energy. So this is one of the trade-offs that has to be considered. There are a number of proposals to improve the processing of renewables. One of them is to have a joint review of projects under NEPA and under the Endangered Species Act, and do that on a regional basis, not just do it on a project by project basis, but look at an entire region and consider jointly under NEPA and under the Endangered Species Act the species and the other impacts of building these kinds of facilities in that region. The Obama administration did that successfully with the Western States Solar Energy Plan. Just a couple of days ago, the Bureau of Land Management announced that they were going to again do something like that for Western Solar. And so this is a way of consolidating reviews, allowing a lot of projects to then satisfy much of their environmental and species review responsibilities under a pre-existing document, just supplementing with any new information or changes. Enhancing the databases that are available to those who are looking at these studies is another major improvement. I'll note that several of the proposals that I have here I derive from some important writing by J.B. Rule of Vanderbilt Law School, who I see is on the line. So thank you, J.B., for these suggestions. Developing standard methodology for mitigation of if we know that these facilities are going to cause certain kinds of damage, have standard methodologies for that. Consider the positive environmental impact of the renewables and granting mitigation credit under the Endangered Species Act. The Migratory Bird Treaty Act and the Bold and Golden Eagle Protection Act pose obstacles in that it can be difficult to get approvals from them, called incidental take permits, so that can be changed. Imposing time limits on the process and expanding the types of compensatory mitigation allowed for the projects. So those are for the species protection laws. Additional proposals outside of species protection. One important one, if it were to be enacted, concerns transmission line siting. As I said, we need a massive increase in electric transmission lines to serve all these renewable energy facilities. Right now, the siting of transmission lines is a matter of state authority. A decade and a half ago, Congress attempted to speed that up by a couple of enactments, giving the Federal Energy Regulatory Commission, what was called backstop authority. A number of court decisions have rendered that ineffective. The Bipartisan Infrastructure Act resolved one of those issues, but it's still a big problem. In contrast, under the Natural Gas Act, FERC has basically sole authority over the siting of natural gas pipelines. So there's the proposal that that kind of authority be given to FERC for interstate electric transmission lines. That was in a proposal that one of Senator Manchin's permitting proposals. It was taken out in the latest iteration at the insistence of Republican senators. But it's still something to consider as a way of greatly expediting the approval of transmission lines. Some facilities are inhibited by crossings of wetlands and streams and require permits under Section 404 of the Clean Water Act from the Corps of Engineers. The Corps of Engineers could issue general permits, which are sort of blanket permits for certain kinds of projects. Congress could exempt renewables on contaminated sites from CERCLA liability. One of the major issues is in the reviews, in the environmental reviews, is too little staffing by the agencies. They just don't have enough people to review the applications. The Inflation Reduction Act includes more money for that. Another big issue is interconnection approvals. In order to plug a renewable into the grid, you need approval from the grid operator, which are often the RTOs or ISOs, and the lines, the queues can take years. So there's also money in the Inflation Reduction Act to increase the staffing for that, but that doesn't happen overnight because all of these reviews are highly technical and it takes time to train people to do them. Timelines can be imposed on how long it takes, how long agencies have to review projects. And there can be default approvals that if an agency takes too long, the approval is automatically granted. One way to speed up the litigation process is to have a statute that would require these lawsuits to go straight to the DC Circuit. And the DC Circuit would review them just on the administrative record. And there would be shorter statutes of limitations to review them. Standard assessment and mitigation measures can be developed so that each new environmental impact statement and other project review doesn't have to reinvent the wheel. Early engagement with local communities, especially disadvantaged communities and tribal governments, is very important. Don't wait until you have a draft environmental impact statement. Talk to them early and often is very important in securing some degree of local consent. For rooftop solar, sometimes it can take months or even longer to get approval from your local building department to build rooftop solar. In some areas in Australia, it's become automated so you can apply for your rooftop solar online and get an approval in a day. I think serious consideration has to be given to that. You know, have clear standards, and if you meet the standards, you automatically get approved. And the final thing I have on the list is Section 401 of the Clean Water Act basically says that state approval in the form of a water quality certification is needed for the issuance of certain Corps of Engineers and other Clean Water Act permits. So those permits are ordinarily federal, but it gives the states basically veto power even over projects where ordinarily there would be sole federal authority, such as natural gas pipelines. Some states have used that to block projects they didn't like, especially natural gas pipelines. And so the earlier versions of Senator Manchin's proposal would reduce that. The latest version has taken that out. And that may be less important in this context because it's mostly natural gas pipelines this has been used against and not electric transmission lines. So that's my basic presentation and a bunch of ideas that are, many of them are going to be controversial. I'm not saying that I personally endorse every one of them, but I've tried to lay out a number of the proposals that are out there to try to expedite the approval of these projects. And I'll now turn it back to Tracy.
Thank you, Michael. As always, a fascinating presentation. A few quick notes and organizational comments. First, please, for everyone watching online, if you have questions, I've asked folks to post them to the chat box. We can try and curate them a little bit. Second, we typically ask our speakers to provide their PowerPoint presentations so we can post them to their website for our speaker series. A couple of you have asked me whether or not you can have a copy of the PowerPoints, and unless, Michael, you have some objections, hopefully we can provide those.
Sure, I'll send them around.
Okay. So with that in mind, let me go ahead and start with one question, which first JB's asked, but several others as well. There's curiosity as to whether or not the Manchin permit reform bill could have actually moved the needle, assuming it had gotten inserted into the National Defense Appropriations Authorization legislation. Or alternatively, prospects for permit reform in the next session with a GOP-controlled House, whether or not we have some prospects for the proposal on the table to actually accomplish some of the things you're discussing.
Right. As most of you know, Senator Manchin tried to have permitting reform in the Inflation Reduction Act. The deal that he struck with Senator Schumer was no, it's not going to be in this round, but we'll adopt it later in the session. Senator Manchin has tried to do that most recently to put it in the Defense Appropriations Act, which was a must-pass bill. That died a couple of days ago. Yesterday, Senator Manchin put forth a new, somewhat whittled down proposal, but it doesn't seem to be going so well either. The progressive wing, the Democratic Party in both the House and the Senate, is very much opposed to many of these elements. And although a lot of Republicans might ordinarily favor much of this, they don't want to give a win to Senator Manchin. They are eagerly looking at his seat in West Virginia, which they hope to take in 2 years. So the latest I've heard is that it's rocky. The proposals that he put on the table most recently would have done some of this. There would have been faster permitting requirements. There would be enforceable deadlines. There'd be better tracking of these projects, some of which is already accomplished under a law called the FAST Act, which was enacted in 2015. So some of the elements of the Manchin bill would have moved the needle. It would only address a fraction of these, and some of them probably would have gone too far. But it may be that who knows what the next Congress will be like in terms of rational action, but it's possible that we'll see serious action on some of this, especially since so much of the Inflation Reduction Act money will go to red states. And so some of those states will, and their representatives in Congress will want to move on some of these.
And I commend you for using the words Congress and rational in the same sentence. Just a brief follow-up question, just to make sure we have a sense of what's ahead. I mean, it does seem that some of the policy proposals you're discussing offer benefits for both red states and blue states. While not a legal question, just looking ahead to next congressional session, are there any real prospects for bipartisan action that seem viable?
I think it's possible. I mean, the trade-offs raise very difficult issues. Speeding off the permitting processes tends to reduce citizen participation, which is a real problem for many in Congress. A lot of concerns about whether it will disadvantage environmental justice communities, whether we're trading off important environmental protections. On the other hand, there are interests that don't want to advance renewables, and some of those interests have a lot of representation in Congress. So very difficult trade-offs. But I think that it is possible, given the large amount of money that is involved, that will go to a lot of different states, and I think that will help. The hope is certainly that it'll create constituencies, powerful economic constituencies that will favor this kind of permitting reform. I mean, for example, in addition to building out all these renewables, we need to resume a lot of mining activity to come up with the minerals that are necessary. Those typically face local opposition. Under the Inflation Reduction Act, we need a lot of that to meet the local content requirements. Those too will be some very difficult trade-offs in getting those approved.
I'll also note that to the extent that some of the infrastructure discussion build-up we're looking at in our discussion today does involve some carbon capture pipeline infrastructure build-out as well, which has certainly drawn a lot of red state support as well.
And opposition from the progressive wing as well, that is skeptical about carbon capture and sequestration as a way of allowing old fossil plants to continue in operation and build new ones. So that too is a flashpoint.
Yeah, I also can't resist adding the small comment from the chat box that some folks have pointed out that there were strong economic benefits for red states to accept Medicaid expansion, which often many of them chose not to for policy reasons. Or political reasons.
Ideological reasons.
Ideological reasons. That's probably the best way to put that. We've also had several questions in terms of whether or not there's reasonable possibility of expecting community participation, given the polarization of the political scene. Ed, I think that you had actually posted one of the earlier questions about this. So I was wondering if you'd like to go ahead and present your question to Michael directly so that folks have a chance to have more participation and discussion.
Thank you, Tracy. Michael and I have talked about this a little in the past. To put it bluntly, I think it's time for us to sort of shoot the sacred cow of community participation. That when you actually look at a lot of the research on community participation in other domains where it's been done a lot, like health policy, the 1993 641 Health Planning Act, when you look at land use where it has been studied some, it really is dominated by well-funded opposition, either individuals or groups. We have a significant fraction of the population in most states, including rural New York, that belong to an organized party opposed to climate change projects in general. And I just don't see any do you see any way to deal with that? Because they aren't interested in compromising on these. It's ideological, as you very well put it.
So I wouldn't shoot the sacred cow, but I'd put it in a pen. I think we still do need community participation. I think people have a right to know what others are planning to build in their communities, and often they can point out some project modifications that would reduce impacts or ways to mitigate the impacts. I think this is very important, and if we don't allow any, I think we'll just have more opposition. I think if something is crammed in without any opportunity for local participation at all, studies have shown that escalates the opposition to it. But I think that so Ed is certainly right that there are organized groups against these projects, but there are also legitimate concerns, and I think we still need to have some community participation.
And if I could jump in, we've actually had some questions along this line in the chat box. I think if I'd boil them down, do you see any sense of willingness to consider time for triage, quote unquote, among some of the larger environmental advocacy groups on the need to actually sort of give ground on some of their priorities to allow some of these renewable energy projects to move ahead?
Yeah, we have a spectrum of environmental groups. Some are more and some are less, and some not at all willing to consider this. There are discussions taking place mostly quietly on this subject because there's always the prospect of offending members, donors, others. It's difficult for a lot of environmental groups to budge on many of these issues. It's similar to the attitude of environmental groups towards nuclear, that traditionally it was a matter of orthodoxy that anything nuclear was bad. I think there's now increasing recognition in some circles that at least the old nuclear power plants that we have, we should try to keep them running as long as that can be done safely. And some of the environmental groups have come around to that view. But I think we still have quite a ways to go in convincing some of the trade-offs that are involved, as I talked about in my article, some of the difficult trade-offs that a lot of difficult bullets to bite.
Yeah, so perhaps the true crucible for that would be when small modular nuclear reactors actually are getting close to physical deployment, what sort of opposition we'll see with those. I guess one other final question from my perspective, just because it's an area of interest. I know many of us in the call were actually returned from COP27 in Sharm el-Sheikh. We've also seen some rising objections being raised to renewable energy build out by some of our foreign trade partners based on treaty obligations the United States has entered into that would arguably limit domestic sourcing, labor restrictions, or other types of potential international impacts or subsidy benefits. I was just curious to the extent that we are not in this by ourselves, if we are going to be taking steps to streamline renewable energy construction development, are there any international legal dimensions that need to be part of that calculation as well?
Well, as you say, objections have been raised under the WTO rules to whether the local content restrictions are a violation of those rules. The ability of other countries to effectively deal with that is limited because the appellate process under the WTO process has broken down, but that's a whole other story. So I think we will see a lot of noise about that. It's not clear to me whether it will actually end up inhibiting these projects. This goes in both directions. There are trade restrictions on the other side. So I think this will be a flashpoint, but I'm not sure to what extent it'll actually be a true impediment.
Excellent. Well, our time is about up. Michael, do you have any other final or concluding thoughts or messages you'd like to share with everyone?
No, I'd love to continue this dialogue. As I say, I see quite a few people who are involved in these issues on the phone, on the screen, and I look forward to continuing this conversation.
Wonderful. And I'll add as a concluding thought that there have been plugs for your piece in the Environmental Forum, which I think I'd like to make sure everyone pays attention to, dealing with your discussion on the art of environmental compromise and dealing with local communities. So with that, thank you for a fabulous presentation. As always, it's fascinating to just talk with you, and I'm sure that we'll be looking forward to policy implications from this subject matter coming ahead in the next congressional session. As a parting thought, I want to first of all turn the mic back to Alban to discuss our upcoming speakers, and also on my part to extend a renewed invitation to everyone for 2023 to make sure that you stay in the community with us and listen to our upcoming speakers. Alban?
Thank you so much, Tracy. Professor Gerard, thank you so much for your insightful presentation. So our next speaker will be Professor Mary Wood from the University of Oregon Law School on January 31st. And our website will be updated and invitation will be sent out in early January. Back to you.
Wonderful. Thank you, Alban. And I will add a supplemental plug, which is that given the now growing number of cert petitions before the U.S. Supreme Court on the climate tort liability lawsuits, Professor Wood's presentation dealing with the children's trust litigation seems especially timely. So hopefully we'll see everyone then. So with that, I once again thank all of you for joining us, and look for Professor Gerard's slides posted to our speaker website. And we look forward to seeing everyone again in 2023. Have a great holiday season. See you soon.